Hi everyone, welcome back to Legalese Translator. My name is Heather Hryniak, and joining me today, of course, is Heather Douglas. Hi Heather.
Hi.
So today we're going to talk about the term motion for summary judgment. So just as a little bit of a context, many people assume that a lawsuit only has a couple of steps. You start a claim and then you go to trial. Actually, there are many steps that happen before you get to trial. Like settlement conferences, for example, discovery or mediation. One very common thing that happens in lawsuits are motions. So Heather and I have already recorded a video on motions, so don't forget to check that out here and just click on the link. So today we're going to talk about an important type of motion called motion for summary judgment. And I would like to ask Heather to give us the basics about what this kind of motion involves. So Heather, what does the term motion for summary judgment mean?
A motion for summary judgment refers to a judgment that's been entered into the court without a full trial. And in Ontario, you can find the rules for a summary judgment motion under Rule 20 of the Rules of Civil Procedure. And it sets out the mechanisms that the court uses to weed out claims or defenses at a very early stage that have no chance of success. It's designed to end claims and defenses that are not factually supported. So the purpose behind this rule is to get rid of an action where it is shown that a trial is not necessary. Under Rule 20.042A of the Rules of Civil Procedure in Ontario, the court sets out the first part of the test. So the court must decide whether the moving party has established that there is no genuine issue requiring a trial with respect to a defense or a claim. So the question is whether a full trial is required for the judge to have a full appreciation of the evidence and issues needed to make final findings, and whether a trial is required in the interest of justice. So in some cases, you need to have all the witnesses in a courtroom, you need to hear everyone's evidence, and the judge needs to go through that fact-finding process. But in other cases, the courts are saying, we don't need to have this extensive fact-finding proceeding with all these witnesses and all the cross-examinations. We can do it more on an evidentiary record that's either only affidavits on cross, or a small mini oral hearing. And we know under, I'm going to butcher it, Hryniak versus Mauldin, it's a 2014 Supreme Court of Canada decision. It is the leading case on summary judgment motions in Canada. This says there's a two-part test for the court to consider. So the court should first determine if there is a genuine issue requiring a trial based on the evidence in the motion record. If there appears to be a genuine issue requiring trial, then the court should determine if the need for a trial can be avoided using the powers under 20.04 and then in brackets 2.1 and 2.2. So the court can then reach into these further powers to try to go through the evidence. So one of the powers is oral evidence can be obtained from a small number of witnesses. So instead of having every witness at a trial, maybe you just have 3 or 4 key witnesses testify in court. B, Another way is the issues is likely to have a significant impact on whether the motion is granted. And then the third power is the issue is narrow and discrete. So the court can look at different factors to see, can we decide it at this early stage based on the evidence before us? And is there something that the whole case turns on? So if you're trying to bring a motion for summary judgment, you're trying to find something that if this one issue is resolved, the whole case is over. You're not going to need to go anywhere further. So for example, if you have a medical negligence claim, and to establish negligence, you must establish causation. And if the whole issue of causation can be determined on a summary judgment motion, then that's the perfect kind of case to go to that motion. Instead of having to hear evidence on every single issue, like the standard of care, the extent of the damages, we can just hear this one discrete issue, the causation, and if it's found not to be the cause, then there's no need for a trial. There's no need to go any further with the case. So judges are looking to see if there's one issue that can finally get rid of, dispose of that case. And if you're opposing it, your job will be to show the court that, in fact, that one issue can't dispose of the case, that there are all these reasons why it can't be assessed either in a form of a summary judgment, or that there are many other issues to be dealt with, or there's a potential of huge inconsistent findings. So they're going to look for reasons why this mechanism can't work in this case.
So that's really interesting. Well, that's a great example. So basically, if you're responding to a motion for summary judgment, you're basically wanting to say, hey, no, judge, we cannot just use this summary mechanism, this abbreviated mechanism to decide a case, because there are all these other things that should be considered, and it's complex, and it's not just a simple no genuine issue for trial type of case. So that's when you respond. Whereas if you're the person bringing the motion, you're like, this is, I wouldn't say slam dunk, but I would say this case really doesn't need to have a full trial. We should just decide it here with this almost like a abbreviated procedure. Am I getting this right, sort of?
Yeah, so you're basically trying to say, if we decide this one point, then we can decide the whole case. If the plaintiff, for example, if you can show that the plaintiff needs to prove A, B, and C to win,
right?
They cannot prove B, and therefore the whole thing must be thrown out. And that issue of B can be decided easily in the context of a motion. The courts are going to want to do that because there's an interest to dispose of cases quickly rather than let them linger in the courts for years.